The First District Court of Appeals, 9th session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you, Marshall. Welcome to the First DCA. We have one case on our docket this afternoon, Seaside Town Council, Inc. v. Seaside Community Development Corporation in Walton County. That's case number 19-755. Seaside's time, we have a cross appeal, so Seaside's time will be divided. First, we'll hear its direct appeal, and then it can reserve for both rebuttal and Seaside CDC's cross appeal response to that. And then Seaside CDC's time can be divided. First, a response to the town council's appeal and also its own cross appeal, and then it can reserve for further rebuttal on its cross appeal if it wants. Counsel for Seaside Town Council, ready to proceed?
We are, Your Honor.
And would you like to reserve any time for your rebuttal as well as response to the cross appeal?
Yes, Your Honor. We would allocate 15 minutes for our initial argument and 10 minutes for rebuttal.
Very well. And we've got the clock there. I'll try to keep an eye on it, but hopefully you can see it as well as I can. So please proceed then.
Thank you, Your Honor, and members of the panel. May it please the court. My name is Dave Smoker, and I'm here on behalf of Seaside Town Council, who is the appellant cross-appellee in this case. The central premise of the summary judgment ruling below was that the only grant made to council in the amendments to the declarations was that of collection of assessments by. The summary judgment record refutes this inference by virtue of a number of the plain, unambiguous organizational purpose language, the 1991 amended declarations, and the articles of incorporation indicate to the contrary, that there was an intent to broadly delegate the sort of authority that a homeowners association traditionally has. Second, the town council's articles of incorporation were pursuant to chapter 617 Florida statutes, and it was granted the general right to sue and be sued, and that right in the articles of incorporation was not restricted in any way. Additionally, there's subsequent evidence of the association's intentional assignment of their rights to sue to enforce the covenants and restrictions in this particular case in 2011. And they subsequently approved budgets for the particular lawsuit in subsequent years consistently. Additionally, there's evidence of the parties' long-time acknowledgement and acquiescence in Seaside Town Council's enforcement of the covenants and restrictions. That record is established in this case as well. The same record also establishes, we believe, that the town council has standing as a matter of law in 4 discrete ways. First, the broad management, operational, enforcement powers that were assigned in the foundational documents. In those broad delegation of administration and management would have arguably included as one of its subjects the ability to enforce restrictive covenants, which primary purposes of having association in the first.
Well, let's ask you about that if we can. The 91 assignment, as you stated, says that STC will assume management of the administration and operation of the association. What does that mean?
I think what it means is, first of all, you must context. Stepping back, remember that this is an acre development. There were 9 separate homeowners associations created within this acres. And if you map H, which is at record 2602, it shows you the Seaside community. Very small. So having 9 separate associations created a need to consolidate and centralize the management and operation of the into a single association. Now, that's the context. So if we then look at that context and we interpret management and association context, we think necessarily would have included the ability to bring lawsuits to enforce the covenants. And that appears to be what the intent of the parties was, as manifested by subsequent events.
Well, CDC claims that because the specific provision in Section 6 on collecting assessments specifically grants a right to sue there, that grant therefore excludes any other right to sue. What's your response to that?
Is severalfold. First, the context of that would indicate that the fact that they had to have an enforcement provision expressly addressing the collection of the assessments was not because they intended to limit the authority of STC. It was because by the same amendments, they were creating a brand new form of assessment that didn't actually exist, and for which there would have been no ability on the part of the associations. So it was therefore necessary to address that, because you had a new form of assessment that was being essentially authorized by these same amendments. I don't think under the context that you can reasonably infer, therefore, from that there was an intent to include the ability to perform what is customarily part of the administration of education.
Counsel, what is it that STC is seeking to enforce specifically?
They're seeking to enforce the covenants and restrictions which incorporate
which one? Which covenant and which specific provision in that covenant is STC seeking to enforce?
It would be the provisions in the 1991 declarations that created and incorporate the Seaside Code, and the Seaside Code and the master plan for the Seaside Code were expressly incorporated in each of the individual associations' covenants. And I would refer you, Your Honor, to the affidavit of Mr. Wiggins, which is at Appendix 91 to our initial brief. And in that, representative declaration of covenant, what it says, among other things, is it creates common areas. Those common areas are in the associations, and in addition, it establishes easements for access to and use of various amenities outside neighborhoods, and creates specific cross easements for the enjoyment of the residents. And specifically can cite you to...
Well, Counsel, here's what I mean. Let me ask it a different way. What is the Development Corporation doing right now that STC contends is in violation of one or more of those covenants?
The primary issue is and concern related to unilateral amendments that were made to the development specifications and other architectural and land use provisions that were established in the Seaside Code and the Seaside RI, which are of the community, and in code in particular is incorporated within and specifically referenced within each of the association's decks.
Right. But specifically, though, how did, is there a document in the record that shows what the Development Corporation did to amend the code, or what provision of the code did the Development Corporation amend, and in what way?
In the second amended complaint, which I think starts at record 150, there are a number of allegations that are made.
Right.
And specifically, we had a complaint for declaratory and relief to amend the Seaside, regarding enforcement of the Seaside Code. And in it, we asserted that the SCDC, the unilateral right to modify terms of the Seaside Code to its particular desires. And we said that, wait a minute, you're making heights, setbacks, development in areas, recreational areas, reservation areas, parcel use restrictions, civic buildings and spaces, and altering the regulations that were applicable to certain of the property within Seaside that was owned by SCDC. And so,
let's start with which property was that? Are we talking about Town Center, Lyceum, or something else?
both.
So Town Center and Lyceum?
That's correct. Those would be the two areas of concern to our client.
And what is the Development Corporation doing with respect to either or both of those? Trying to build a hotel or something else?
For example, they converted a particular area that had been designated for recreational purposes into residential. They had also restricted and limited areas that were recreational, convert them into more of commercial enterprises for commercial recreational purposes. There were examples of where they allowed for travel trailers to be lined up along 30A within the town center area for commercial purposes. There were other examples of where our client felt that the SCDC was effectively commercializing areas that were really more of a civic nature, and which would be should have not been used for commercial purposes, but should have simply been used for civic purposes for the benefit of the individual lot owners within Seaside.
But aren't those two areas, Lyceum and Town Center, governed by the separate covenants and restrictions that were included as Composite Exhibit D to the summary judgment motion?
Yes, they are, Your Honor, and they were, but it's important to understand that the whole concept of the community of Seaside isn't something that is simply subdividable. It was originally planned for to map H as a single unified mixed-use development, which had inextricably intertwined the commercial and the residential uses. Now, SC has platted both the Lyceum area and the town center area as part of the Seaside subdivision. Additionally, if you look at the declarations for each of those, what you will find is that there's express reference to, in the declarations for both the Lyceum and for the town center, of code and the notion that this is a unified community. And when you take that into consideration with the fact that the covenants and restrictions of the association also created rights to use of the Lyceum and of the town center and of other amenities specifically provided for in the association's individual covenants, you find that this sort of legal separation of the town center from the neighborhoods was never. They were supposed to be a community, and the Seaside Code, which is incorporated within each of the association's declarations, it binds the whole community of Seaside together as one, as a community. Now, knowledge that SCDC can provide for different rights with each of these declarations, but what it can't do is separate itself entirely from the Seaside Code, which was essentially put out there for the benefit of selling lot residential areas and created a common scheme development for the entirety of Seaside.
Can I direct you back to standing and the claim that the town center has standing in its own right to assert its interest, not derivative of the various neighborhood associations? What gives it that standing?
I think it has what we would call associational standing. And I think that associational standing derives from express delegation from the associations of the authority for common management and administration.
Well, that's your Department of Labor case that you cited, but the associational standing is different than the town center suffering its own injury that it has a right to sue for. Did it suffer an injury that it's got a right to bring the suit?
Yes, I think it did, and it gets back again to what its purpose was. We would contend that its purpose was for common administration and management of the associations, and that whatever was within the ambit of the association's authority was essentially delegated, and it is to provide a service. It's business to the associations and their members, which is to centrally manage the affairs of all 9 of the. And I think that gives it the sort of business and economic interest that was being directly affected by the actions of SCDC.
Let me also ask you, I know we're now into your rebuttal, but we can give you some more time. On your claim of standing as a homeowners association or an association under 720-3019, membership, the voting membership in STC isn't made up of parcel owners, right? So how does that make you an association under that specific definition?
Your Honor, I think it's because the way in which the legislature chose to define an association, and it talks in terms of a corporation being responsible for the operation of a community in which the voting membership is made up of parcel owners or their agents. For example, an association would be an agent of the parcel owner, or a combination thereof, and in which membership is a mandatory condition of parcel ownership. As to the individual lot owners, membership is mandatory in the association. As to STC, the association is membership in STC is mandatory. And so what you're dealing with is what the legislature refers to as a combination thereof. This is precisely the sort of combination thereof that the legislature contemplated, because it knew that I say it knew. I think it's reasonable to infer that the legislature knew that they needed to create a flexible structure with the ultimate purpose being to ensure that the affairs of associations can be properly managed, be by a master association, whether it be by an association consisting of a combination thereof. But the point was, and the overall purpose was, to be able to allow for a corporation to serve as the manager and administrator and operator of these associations. And so I think that the statutory language is sufficiently flexible. And I would note that to allow for us, STC, to be an association, point out that esteemed counsel for SCDC did acknowledge that we were serving as an agent. And I think that's really the best way to look at it. Is what we've got here is we have parcel owners, we have associations, and we have an agent for both. And that is what STC functions as.
Thank you. Judges, did you have any more questions before we hear from Mr. Emanuel?
I can wait for rebuttal.
Okay. Well, why don't we go ahead then, and we'll turn to Mr. Emanuel. We'll add 3 more minutes to each side so we can have plenty of time for rebuttal. Thank you, Mr. Smoker.
Thank you.
Mr. Emanuel, then, did you, sir, want to reserve some time for rebuttal on your cross appeal?
Yes, 4 minutes, please, Your Honor,
Okay,
with
so-
the extra 3 being given. And I was asked by the clerk to disclose anyone else in the room with me. And I have one of my partners, Adam White, who has worked on this case with me, one of our law clerks, Gabriella Jeter, and an IT person to make sure we stay connected.
Okay, very good. Thank
So
you.
those 3 are in the room with me.
So we'll reserve
Judge
4
Barbary,
minutes.
I'd like to,
Go ahead.
thank you. Judge Barbary, I'd like to start with your inquiry, which I think really gets to the point. And as Judge Green correctly found, he looked at the actual verbiage of the 9 assignments and what rights were transferred, and more importantly, what rights were not. And the 9 assignments could not be clearer. In Section 6, they all say enforcement. And the only enforcement rights assigned by the 9 associations to the town council was the right to enforce assessments. All of the other enforcement rights, whether it be someone improperly using their property, trying to operate a commercial business in their home, all those enforcement rights were retained by the 9 associations. And council's argument that the fact that the 9 assignments reference administration and operations of the association, how could you interpret that as meaning the 9 associations were transferring all enforcement rights of both the 9 associations and the several hundred owners to the town council? That is completely belied by the actual wording used in the 9 assignments. Council refers to the articles.
Judge Green applies the expression of one thing excludes the other maxim. I'm not going to say it in Latin because my Latin's not very good, but that by specifically expressing in Section 6 the right to sue for assessments, that excludes any other right to sue. What in the agreement is ambiguous such that you have to resort to contractual construction or statutory construction maxims?
Well, Your Honor, first of all, Judge Green did not use that term, the Latin term. He just said, I look at the documents, and he says with regard to, in page 2 of his summary judgment, in amending their respective declarations to delegate certain duties and authorities, the 9 neighborhood associations gave STC the power to, and then he lists them. And then he goes on to say, concerning enforcement authority, the only grant made to STC in the amendments was the authority for assessments. He's just reading the document and interpreting it according to its clear wording. Counsel for STC will say, no, what you should do is ignore Section 6, because if, as STC contends, the assignment of a right to manage included the assignment of all enforcement rights, then there would be no reason to have Section 6 in the assignments at all. Additionally, as outlined in the Sprint Corporation case, as we cite, when setting up an agreement, and Sprint it was an operating agreement, the parties can agree that certain parties are going to have limited authority. And clearly the authority granted to the town council was limited.
Well,
additionally, Judge Green found, go ahead, Judge.
What he needed to do was construe what administration and operation of the association means?
Judge, I think that is correct, but that in light of the fact that a specific limited enforcement power has been transferred, and again, for this court to adopt the construction requested by STC, this court would have to conclude that every one of those owners and every one of those 9 associations intended by these limited assignments to assign all enforcement rights to the town council, meaning that after that assignment, if I was an owner in one of those associations and my next door neighbor started to violate the covenants, I would not have any right to enforce it because I would have assigned all the enforcement rights to the town council. And clearly these assignments cannot be read that broadly. They must be read according to their actual terms. And as we cited also, Your Honor, in case law, that the grant of the assignment is the Constitution that takes precedent over the Articles of Incorporation. And the Articles of Incorporation cannot grant to the town council broader rights, broader authority than what was assigned by the 9 associations.
Well,
And clearly the 9 associations.
The town council is a Florida nonprofit corporation that has a right under 617 to sue and be sued, right?
Your Honor, that is correct, but that, the right to sue and be sued does not convey standing. If the right to sue and be sued conveyed standing, then the town council would have the standing to sue anyone on anyone's behalf. Clearly, that's nonsensical. So the fact that they have the right to sue or non-sue does not give them standing to pursue a particular case.
But you're arguing kind of the inverse of that, that because they weren't specifically granted the right to sue, then their statutory rights are somehow restricted. They weren't granted
the statutory rights.
Go ahead.
The statutory right to sue and be sued cannot create rights greater than what were assigned to them by the 9 associations. And I think that is important for this reason. The claims of the town council in this case are not that SCDC has done or is attempting to do anything within the bounds of the 9 neighborhoods who formed the town council and granted to them the limited rights given to the town council. As Judge Green correctly found, the only community as to which the town council has any rights are the portion of Seaside within those 9 neighborhoods. And as is clear, there are large portions of Seaside that are not within those 9 neighborhoods. There are other neighborhood associations within Seaside that are not part of the town council. The town center, all of the civic property, all of the recreational property, the Lyceum, Judge Tannenbaum referred, none of that property is within the 9 neighborhoods. Seaside Town Council has no rights as to those. And yet,
Council, that doesn't sound like
council,
Council, that doesn't sound like a standing argument. That sounds like a merits argument. I mean, if the agreement had said that we delegate every right we have under these agreements to sue under anything, you're saying that they still wouldn't have the right to bring this action because it involves different property?
Your Honor, that is correct, Your Honor, because the claims made relate to property outside the 9 neighborhoods, then the town council would not have standing to pursue those claims. Now, as Mr. Smoker indicated, and as we've outlined in our materials, what makes Seaside somewhat unique, it is a development of regional impact. And that DRI, now the essentially built out agreement, has served as the master plan for Seaside since 2001, when it was adopted by the county and approved by the state and recorded in the public records. And that essentially built out agreement governs what anyone is allowed to do anywhere in Seaside, what is allowed to be put in the town center, what is allowed to be put in the Lyceum, what uses are allowed within the 9 neighborhoods, what uses are allowed in the other areas of Seaside, the civic, the recreational, the commercial. And that is what governs what SCDC and any other owner in Seaside is allowed to do. Council refers to the Seaside Code, and there is a code. Seaside has what is called a form-based code. And what that means is, what a form-based code tells you is, it's not a zoning code that says, can you put a residential use here? Can you put a
Got a little
commercial
lightning
use
close
here?
by, so if we lose you, we'll get back to you.
What the Seaside Code does, it's a form-based code that says, in Seaside 1, if you want to build a home there, this is the form that home must look like. This is architecturally what it can look like. It doesn't give you the right to build a restaurant in an area that's designated residential, or to build a hotel in an area designated residential. All that is governed by the essentially built out agreement. And if anyone wants to do anything within Seaside, if SCDC hypothetically wants to build a hotel, then pursuant to the EBO tells where within Seaside a hotel could be built, and under the entitlements, how many hotel rooms are available to be built within Seaside. And so that governs what type of uses can be put within Seaside. And that governs the town center, Lyceum, recreational, the 9 neighborhoods, the other residential areas that are not contained within the 9 neighborhoods. And so when you look at the concept of community, which one of your honors raised a question about, when you look at chapter 720 and you look at within the confines of a development of regional impact, how community is defined under 720-301-3, community is defined with regard to a development of regional impact as the entire property composed of the DRI. So for an organization to be a 720 association for purposes of a development of regional impact community, it must be an association that has rights and authority over the entire DRI community. And when you look at the definition of homeowners association under 730-301-9, it makes clear that for an entity to be a homeowners association for 720 in a DRI community, every property owner within the DRI must be a member of that association. And every property owner within the DRI must be obligated to pay assessments to that association. And it is undisputed that there are substantial associations and non-association owners in Seaside that are not members of the 9 participating associations that are part of STC, are not members of any of those 9 associations, do not pay assessments to the town council, and as to which the town council has no rights of enforcement to collect assessments. So when you look at the definitions of 720 for both what a community is for purposes of a DRI community, and therefore what a 720 association must be in charge of to be a 720 association within a DRI community, it's clear that the town council does not meet that requirement. And Judge Green found, go ahead, Judge.
Wanted to go back to, you've been talking about all these areas that aren't subject to the 9 homeowner associations or the 9 neighborhoods. And I'm still having a hard time understanding what the development corporation has done that has prompted this lawsuit in the first place. And I haven't gotten specifics yet. And I'm curious, what are we here for? Like, what is the actual wrong that has occurred? And it under, or do you feel that it is under the 2 covenants that govern Lyceum and the town center, or it's something else? And if it's not the neighborhood association covenants, what is it?
Your Honor, it's a very good question. There are a couple of complaints that are contained in the Second Amendment complaint. The first is dealing with property called the motor court. And within the commercial area, okay, if you look at the town center, it's on the eastern side of the town center.
Okay.
It's part of the town center.
It's in the town center part.
It's in the town center. And it's a motor court that was built to look like a 50s motor court. 1 story high, you pull in, there's hotel rooms. And several years ago, a developer thought about redeveloping that property and putting a larger hotel there. And that was discussed. No application for a development order was ever submitted. No plans were ever approved by SARC, the Seaside Architects Review Committee, for that hotel. And the motor court still operates and exists today in 2020. So the contention in the lawsuit filed in 2011 was someone was talking about redeveloping that property, and we didn't like the way it was going to be redeveloped. It's never been redeveloped. It's still there.
Well, you mentioned
with regard to the light.
Go ahead.
With reference to the Lyceum, the contention was that post-Hurricane Katrina, The Lyceum, Judge, is fashioned after the large area at the University of Virginia and designed to have education around, to have a theater at the top end. The Seaside School is on the two sides. And Robert Davis had the idea that to support that academic use, to put some small cottages there that could be used by academics that come to visit at Seaside. For example, the Notre Dame School of Architecture comes down to visit. And so those cottages were built there. The town council took the position, well, that violates the Lyceum covenants. We took the position it did not.
Okay, but my point or my question for both of those. So the Lyceum covenants and the town center covenants. A couple questions about that. First, you mentioned SARC, but is it not the case that isn't it still the development corporation that is the sole arbiter of development approval or building approval there, or where is the SARC appear in those covenants?
Right, Your Honor, other than Seaside 1, that one small neighborhood, as to the other 8 of the 9 participating neighborhoods and to all the other property in Seaside, SCDC, through the covenants, has retained the right for architectural control. But having done that, the EBO governs, for example, in the town center, what can be built there. So although if someone wanted to redevelop the motor court into another hotel property, they would have to go through SARC for approval. SARC cannot vary from the requirements of the essentially built out agreement or the covenants of the town center. And so the architectural
review— is there one SARC or 8 SARCs?
There is one SARC, Your Honor, that is controlled by Seaside Community Development Corp, with one exception. When Seaside 1, when those covenants were recorded, SCDC did not retain the right of architectural control. Now, Seaside 1 has been built out for 25 years, but if hypothetically an owner in Seaside 1 wanted to tear down a house and build a new one, then Seaside 1 would have the right of architectural review and control over that redevelopment. For anywhere else in Seaside, SCDC, through SARC that it created, has that right, but it is not a right to approve whatever they wish to approve. That approval must be consistent with the essentially built out agreement, with the particular covenants that control that portion of Seaside, and to the extent applicable, Walton County's Land Development Code and Comprehensive Plan. So that if someone wanted to—
Who gets to enforce the rights, or let's say the development corporation didn't abide by the terms of the covenants for town center or Lyceum, who can enforce that?
Right. For the town center, for example, Your Honor, all the owners in the town center would have enforcement rights of those covenants, just like an owner in any development that has covenants applicable to that portion have a right of enforcement. Separately, since Seaside is a DRI, the county has enforcement authority under Chapter 380 to enforce the DRI, now the EBO. So if hypothetically SCDC or anyone in the town center wished to develop property in a manner that was inconsistent with the town center covenants, any owner could pursue that, or that association could pursue that claim. Additionally, when that applicant applied to the county for a development order, the county would review that application to see whether that proposed development was consistent with the essentially built out agreement, the Walton County Comprehensive Plan, and the Walton County Land Development Code. And if it was found not to be in compliance with all those as applicable, then the county could deny the development order. In addition, if a development order was issued, anyone affected by that development order, as defined under Chapter 163, could file a consistency challenge as to that development order to the extent it did not comply with the comp plan or the land development code, or anyone in Seaside, if they believe that that development order was not in compliance with the essentially built out agreement, could write to the county and ask the county to utilize its inherent enforcement power under Chapter 380 to enforce the EBO and prohibit the development that would be in violation of the EBO. So development within Seaside is highly structured.
But what your position is not is that any of those homeowners and any of the 9 associations could not directly sue the development corporation for not complying with the EBO or the DRI.
Your Honor, that is correct. Under Chapter 380, there is no private cause of action in favor of any private party to enforce a DRI. That's the way Chapter 380 is set up. Instead, the county is charged with interpreting, applying, and enforcing a DRI/EBO, but anyone can request the county undertake that enforcement authority, and then the county can, pursue that. Now, if there was a claim that there was a violation of the town center covenants, then any property owner within the bounds of those covenants would have an enforcement right. Just as if someone in Seaside 1, if I was an owner in Seaside 1 and I tried to open up a restaurant in Seaside 1, then any property owner in Seaside 1 would have the right to enforce those covenants within the bounds of those covenants. So like a lot of large developments, Seaside has various subparts that are subject to different covenants that are designed for different uses. There are, for example, 2 condominiums in the town center in Seaside. Those condominiums have their associations with their covenants and restrictions that those condominium owners have the right to enforce as to other owners within that condominium. So Seaside has all different covenants and restrictions that provide protections for those particular owners, but also as to the entire community, there are the protections of the EBO and DRI, which serve as the master plan for everything, as well as the protections of the comp plan and the land development code as applicable to any potential development within Seaside as well.
Let me ask you.
And so those are the
before we run out of time.
Yes, Judge.
The Mr. Wiggins affidavit, where he says the 9 associations have assigned their rights to sue. Why is that a legal opinion? That I've assigned my right, I've sold my car, I've sold my house. I mean, you may refute that and say, well, no, there wasn't a bona fide purchaser for value or something like that. But a layperson can testify to those kind of things.
Well, Your Honor, there's 2 problems, well, several of Mr. Wiggins' affidavit. First of all, Your Honor, the 9 association covenants had a specific amendment process that was required in order to assign any rights under those covenants. And the associations knew those requirements. Like almost all covenants, they require an affirmative vote of a majority of the owners in each association. And that's what was done in 1991 with the very limited 9 assignments. And what Mr. Wiggins says basically is disregard that. In 2011, the 9 associations, and it's unclear exactly what was done, they just voted to authorize this lawsuit, which means they could ignore the protections provided within those written covenants. And those protections were there to design to protect the rights of every owner, that those rights could not be taken away by having 9 presidents vote to give away rights. If I was an owner in Seaside 1 to say, well, Mr. Wiggins can't just do an affidavit say, I've now deemed to have assigned to some entity all of my enforcement rights as an owner within that particular association. I think his affidavit is also rank hearsay for him as an individual to say, okay, 9 associations voted. Well, it's clear the 9 associations did not execute amendments as required by the terms of those association documents, which the associations did in 1991. So it's obvious they did not do that, which the covenants and restrictions would have required if they wanted to further assign something to the town council. So, Your Honor, if today those 9 associations said, okay, we would like now to assign further enforcement rights to the town council, would they have the right to do that? I think the answer is yes. But they would have to follow the covenant amendment process in order to do that and have it be effective and binding. They cannot take away the rights of those owners in those 9 associations to be able to vote on whether to transfer those additional rights. And with that, I'll retain.
We're in your rebuttal time. Why don't we hear from you on your cross appeal and give you 2 more minutes, both sides, so we can address that.
Yes, Your Honor. And very quickly, Your Honor, our position is very clear. If you look at 72305, it says, okay, an association can sue a member for allegedly breaching the covenants. And if any such lawsuit is brought, the prevailing party is entitled to recover fees. Now, Judge Green found, and we think he erred in this regard, that since he found that the town council was not a 720 association, and therefore relief was not available under 720, that even though SCDC prevailed on that claim, that SCDC was not entitled to fees under that provision. And we think 2 cases stand for the proposition that we are. First, Your Honors, we cited the Holiday Isle improvement case, which is a 2018 case from this district. And in that case, an association sued a developer, and they did not even invoke 720. They just sued, saying the developer was required to obtain.
Let me jump to it because we're short on time. 72305, assuming that applies, town council, assume that's a homeowners association, but CDC is not a member of the homeowners association, right? So how does CDC fall under 72305-1?
Your Honor, it's because the town council alleged we were. They alleged that they were a 7 association. They alleged that we breached 720, and they alleged that they had rights under 720.
They didn't allege you were a member, an officer, director, tenant, guest, invitee.
They alleged that we breached 720, Your Honor.
But the statute doesn't apply, though, in all circumstances. It only applies on the specific terms. So I'm saying on the specific terms, assuming that statute would apply here, what specific terms, who's the member, who's the association, such that that would apply?
Right. Okay, Your Honor, I think if you look at the Diamond Aircraft Industries case, what that case stands for, the proposition, it was a FDUPTA case. Plaintiff sued alleging breach of FDUPTA.
I'm familiar with the case, but what I'm saying is not every suit under 720 falls under 72305-1. And I'm asking how, even based on, some reciprocal, good for the goose kind of thing like Diamond Aircraft, how you fall under 72305-1.
Well, Your Honor, they sued alleging they were a 720 association. They sued us for allegedly breaching 720. We could only breach 720 if we were subject to it, which means within that association. Now, did they use the word member in the lawsuit? No. But clearly, if they were alleging that they could sue us for breach of 720, if we were a stranger to that association, by definition, we couldn't breach the association.
How do you get around
720?
How do you get around 720.302 subsection 3B, which is that the chapter doesn't apply to commercial and industrial parcels in a community? It contains both residential and parcels that are intended for commercial use. Didn't you already say that Town Center and Lyceum, which I thought this was mostly about, is primarily commercial or non-residential?
Your Honor, good point. The Town Center is commercial. The Lyceum is civic. And
but not residential.
Part of the convention, not residential. But the point is this, if you look at that carve out of 202, it carves out commercial and industrial. And part of the contention of the town council, I think Mr. Smoker would agree, they contended that SCDC was not properly recognizing the recreational use for recreational areas in the civic use. And so they were contending that SCDC in non-commercial areas of Seaside were committing violations under 720. And
Right, but isn't
the point is under the
Lyceum is at least primarily intended for non-residential use, isn't that right?
that is correct, but again, the
That's
carve out, Your Honor,
subsection
under
3A.
I think the carve out that you were referring to, I think, is commercial and industrial.
But then 3A,
And so-
the one before it says a community that's composed of property primarily intended for commercial, industrial, or other non-residential use. The chapter doesn't apply to. So between A and B, 3A and 3B, wouldn't the chapter not apply to this lawsuit at all?
Your Honor, I think you could argue that the point under Diamond, as I read it, is it's not what the ultimate outcome of the lawsuit is. As Judge Berbridge said, it's the goose and gander. If I sue under 720, just as if I sue under FDUPTA, and I invoke those statutes and ask for relief under those statutes, including attorney's fees, and the other side wins, the other party, that party is entitled to fees under the statute. And if you look at 72305, it says the prevailing party in such litigation. It doesn't say the prevailing association or member. It doesn't use that same list. And so it says party. So I think clearly the intent is that you could have a party in such litigation other than the association, a member, a tenant, because otherwise the attorney's fee would say the prevailing association or member would be entitled to fees. And the statute says the prevailing party. Clearly, we were and are a party to this litigation. That's beyond dispute.
Thank you, Mr. Manuel. Why don't we
Thank
give you, we've gone into your rebuttal time once again, so why don't we give you one more minute of rebuttal on the cross appeal. So I think that'll give Mr. Smoker 2 more minutes then total, in addition to the time that we've already granted him. Again, don't feel compelled to use that time, but we want to be fair with our division of time. So Mr. Smoker, we will turn to you for rebuttal and as well as response to the cross appeal.
Thank you, Your Honor. First of all, it's true that Judge Green did not use the words expressio unius, exclusio ulterius. Effectively, what he did do, though, was he did apply the rule of strict construction, which we contend was not properly applied in this particular instance. And we've cited in our brief the Hunters Property Association and the strict construction, which is really what Judge Green did. It does apply it only applies in the situation where the issue in the case is the use of property, not where you're dealing with some other type of provision in covenants and restrictions. And the whole concept is based on the notion that use restrictions are in common law. Delegation of authority under a contract is certainly not in derogation of common law. And so I think that he misapplied implicitly the doctrine of strict construction, which, by the way, should not be used in order to essentially defeat what would otherwise be the manifest intent of the parties here. If it would frustrate the clear purpose of a homeowners association management and control turnover provision, it should not be invoked. And we've cited the Silver case for that proposition. With regard to the argument by my esteemed opponent that we're arguing that the members, parcel owners, and the associations that saying they can't bring suit to enforce covenants, we're not saying that. We're just saying there's now an additional party that can, by virtue of the facts of this case, that could bring a suit to enforce covenants. With regard to the hierarchical argument, expand the scope of a delegation by virtue of your articles of incorporation, I would simply point out to the court that, and this would be at page 81 of the appendix to the brief. I'll read this to you. It defines the object and purpose of the corporation. It states, quote, "Corporation shall be a not-for-profit corporation and is organized to permit the neighborhood association administering the various declarations of covenants, conditions, and restrictions applicable within the planned community known as Seaside to provide common administration to the community. Conditions and covenants and restrictions were the object of the parties' incorporation of Seaside, and therefore this hierarchical argument is not only inconsistent with the facts of this case, but it's also circular because it presupposes that delegation to delegate in the first. Additional.
Counsel, what is the origin of the right that you contend has been assigned to the town council? Where does that right start? Like, is it in a document somewhere? Is it in a statute?
Yes, Your Honor. And specifically, it's in each of the declaration of covenants and restrictions for each of the associations. There is a provision here. If you look, bear with me a minute.
Is the Development Corporation a party to each of those, or subject to the restrictions in each of those? If those govern the 9 neighborhoods, how is it that the Development Corporation can be?
Because the Development Corporation was the declarant under these covenants. In other words, he, SCDC, was the party who specifically granted to each association. Read you the operative language because it's pretty much the same for all of the associations. It's in Article 10 provisions for enforcement, and that would be at 5 of the appendix brief. Article 2, the associations or any owner shall have the right to enforce by any proceeding at law or in equity all restrictions, conditions, covenants, reservations, liens, and charges now or hereinafter imposed by the declaration.
I understand. That's not my question. My question is where in any of these 9 sets of covenants is the Development Corporation restricted in what it can put or how it can develop Lyceum, Town Center, or one of the other non-residential properties that are not subject to these 9 sets of covenants?
By virtue of the code, and it is an integral part of the associations.
Well, that's right, but the code applies to the neighborhoods under each of these individual neighborhood covenants and restrictions.
No, the Seaside Code applies throughout the entire community of Seaside as applicable.
That may be, but as to the covenants, each of these 9 sets of covenants, it only the code applies restrictions to each of those 9 neighborhoods through the covenants and restrictions.
It also grants rights, and that's important. It's not just didn't provide neighborhoods. It also granted rights to the individual members with respect to lands outside of the neighborhoods. That would include common amenities, the Lyceum, for example, the beach access areas. There were a number of areas outside of the neighborhoods that the individual associations and their members were granted easements and rights of use, which extend beyond the boundaries of the individual neighborhoods.
Well, that's rights of use. That's not controlling what the developer can do with the property that it owns outside those 9 neighborhoods. To
the extent that their rights in the use of those properties, that the rights in of implicate by investment on its property, I think the answer is yes, they would have rights to enforce the Seaside Code and rights that extend beyond just the neighborhood. Your Honor, also, you asked what were the specifics, complaints, and I direct your attention, I'm going to read them now, but I would direct your attention to with respect to count 1 of the second amended complaint, read paragraph 30. With respect to count 2 of the amended complaint, read paragraph 45. And with respect to count Roman numeral 3 I would direct your attention to paragraph 51 and 52. There we say in great detail what the specific of wrong were here on the part of SCDC.
Why isn't Mr. Emanuel correct that that none of the homeowners have a private right of action and it has to be pursued through the county? That this is actually you're presumably asserting violations of the EBO or the DRI or something, and it has to go through the county.
Well, the Second Amendment complaint does not assert any violations of the DRI development order. It's limited strictly to the covenants and restrictions and the incorporation of covenants and restrictions of the Seaside Code and the Seaside. So the answer is he's conflating two separate legal grounds for bringing an act, not bringing an action to enforce the development order or challenge the development order. We're bringing action to enforce contractual rights of the covenants, restrictions, and declarations.
And so that gets back to, so that's my main question. So I'm having trouble understanding how there's a justiciable controversy in the first place in this whole case. And so your contention is that this is actually a contract dispute, and it's between, is it between the homeowners and the development corporation?
It's between the Seaside Town Council as agent for the associations and the members. And it is a claim based on contract.
Okay, and each of the members of each of those 9 associations assigned their contract rights to the associations, and then the associations assigned all of their rights to the town council? Is that the contention?
The contention is that they added an additional association, sort of along the lines of a master association, but technically it wasn't created exactly like a master association, to go ahead and enforce the same rights that the individual members and the association had. It's not as if STC is claiming we got everything from them and they don't have it anymore. What we're saying is there was an additional layer here of centralized management and administration of the covenants and restrictions that was really needed, I mean, as a practical matter. I mean, the idea that you have a homeowners association consisting of like 9 separate 5-acre parcels does become a little unwieldy. And I think the whole purpose of this was to centralize those functions. I would like to point out on the community argument, and I still see I have some time here. The Lyceum declarations, and this is at record 2549, in their statement of purpose, they specifically cite to the Seaside Code. They say, quote, all of Seaside, all, is subject to a master plan and an architectural guide known as the Seaside Urban Code. In other words, this is an acknowledgement that the whole common scheme of development, which was incorporated within the original declarations and covenants, is not something that's intended for SCDC to simply ignore as it would relate to the neighborhoods.
But do you agree that under Article 5 of those covenants that the developer has the sole discretion to grant requests for building permits and variances?
I would say it does say that, but I think it's subject to the Seaside Code. In other words, he couldn't make the Seaside Code just go away by simply saying, I have all discretion. He didn't reserve unlimited discretion, and he didn't insulate himself from taking actions that would disrupt the common scheme of development under the Seaside Code. These covenants are subject to the rights of the homeowners association under the Seaside Code.
But in 5.1D of Article 5, it does say that the developer reserves the right to grant variances from the Seaside Code based on architectural merit and on existing landscape conditions. Do you agree that that controls still?
That is exactly what it says, and it clearly has an articulable standard that relates back to the Seaside Code, which the which the neighborhoods would have the right to enforce.
Before you run out of time, can you talk about the cross appeal briefly and explain why you contend Diamond Aircraft doesn't apply to mandate the town council pay fees, assuming we don't reverse on this standing issue?
Very simply, Your Honor, I mean, I think you made the point. In the Diamond Aircraft case, fiducia, that's the right way to say it, applied to any defendant and any plaintiff who brings a claim under that statute, whether they're successful in maintaining it or not. If it doesn't apply, the court held you're still subject to fees. The Chapter 720 has a specific limitation of the parties that it is intended to give prevailing party rights to for attorney's fees purposes. So unlike Diamond Aircraft, where there was no limitation, in this particular instance, the legislature chose to limit the scope of those parties that could bring a claim for prevailing party attorney's fees, and the developer was not one of them.
Thank you. Judges, any further questions for Mr. Smoker? Oh, thank you, counsel.
Thank you, Your Honor.
Thank you.
Mr. Emanuel, you had some brief time for rebuttal on your cross appeal.
Yes, thank you, Your Honor. And just briefly, Your Honor, I think what it comes down to is this. Clearly, the town council sued SCDC under 720, alleging SCDC had breached 720. I think under the Diamond Aircraft case, what the Supreme Court is saying, if you bring an action pursuant to a statute, alleging breach of that statute and claiming the right to recover attorney's fees under that statute, and the statute's found not to be applicable, you're still subject to fees in favor of the party that you sued. And that's what Diamond Aircraft said. There, the plaintiff sued under Florida PDUPTA. The court found that statute did not apply because another state's law applied. The plaintiff then said, well, since the statute didn't apply, you cannot award fees to the defendant under the statute. And the Supreme Court said, no, the heads I win, tails you lose does not apply. If the plaintiff comes in and makes a claim and loses, then the plaintiff is subject to that and cannot try and turn a sword into a shield. And that's why we believe that we are entitled to recover fees.
Thank you,
Thank
Mr.
you.
Emanuel. Any further questions from the judges? Seeing none, with no further business to come before the court, we very much appreciate the arguments from counsel, and we are adjourned. Thank you.
Thank you very much.
Thank you very much.
Appreciate your time.
Thank you.
Thank you.